Good morning, all.
Good morning.
Good morning.
Morning.
Good morning.
Good morning.
Good morning.
Good morning.
Good
Good
morning.
I apologize. I'm having some connection issues. This is my third attempt at this. Can you hear me clearly or is it intermittent?
I can hear you clearly.
I
Can hear you clearly.
Okay, good morning. My name is Denise Dorset, and I am going to be assisting you more or less with modules 1 through 5. And I think we have classes each Saturday. I don't have this is my book from the last class, so I just want to know if you have 5 classes or if I'm doing the 5 modules in a shorter period. Do you have your book?
Yes, ma'am, we have this is Kendra. I do have a book and it does have you scheduled for 5 classes
So we
within
do
5 weeks.
Okay, good. So we're doing 1 unit per week.
Yes,
I
ma'am.
just wanted to make sure because sometimes we incorporate 2 units in 1 week. Okay, so I don't know, we can perhaps do a little introduction and then we can move right on. My name is Denise Dorset. Like I said, I do the employment law class with the Bahamas Institute of Financial Services. I'm an attorney and I also do consultancy work with in the legal environment, and of course I assist with part-time lecturing at the Bahamas Institute of Financial Services. I've worked in offshore and public and in private banking. So you can give me a little bit about yourselves and we can begin. I don't know, anyone wants to get started and we can go from there.
Okay, I will start. My name is Kendra Martin.
Mhm.
I am a senior administrative assistant at the Central Bank. Sorry for the pause. A senior administrative assistant at the Central Bank. And I've been there for 20 years. So there isn't much other places I can possibly say I would have been employed. And I'm a mother of 3. I'm currently working from home. And that's pretty much me in a nutshell.
Okay, thank you. And this course is to assist you in your work environment?
This course actually is to assist me personally and professionally. I have a degree in HR management. So
Okay.
this course I think would be very beneficial along with that in my present as well as possibly my current pursuit in the HR arena.
Excellent. Okay.
Yes,
Thank you,
ma'am.
Kendra. Next.
Good morning, everyone. My name is Shanice McDonald. I work for a company called Bahamas Wellness, a medical facility that has 2 branches in Nassau and Eleuthera. I am the human resource manager, been there for almost 3 years now. It's a relatively new company, and so I'm taking up this course. My degree background is HR as well. I'm taking up this course to better myself and to help the company along as we continue to grow.
Okay, thank you, Ms. McDonald, and welcome. Next.
Okay, I can go. My name is Tadashi Palacios. I'm presently employed at the Gaming Board for the Bahamas. I've been there for about 5 years. Throughout my career, I've worked in the hospitality industry, in the banking industry, all a part of the human resources field. I've worked in training. I've dealt with compensation and benefits. So I'm mostly, I would say, a generalist when it comes to human resources, and I just want to upgrade and better my knowledge as it pertains to employment law. So that's my goal with this course.
Okay, thank you, Ms. Palacios, and welcome. Next.
Hi, good morning. My name is Nikita Isaacs. I'm the legal manager at NHIA. My background is law. I'm an attorney by profession. Started off in litigation at Gale Lockhart, Charles & Co. Moved on to Family Guardian for about a year, and I've been at NHIA for almost 3 years now. And I just thought this course would be helpful in dealing with some of the employment-related issues that we have occasionally. Thank you.
Thank you. Welcome, Ms. Isaac.
Good morning. My name is Catherine Zervos. I am with the Cape Eleuthera Island School in Eleuthera, and I serve as the Chief Administrative Officer and the HR Director. I have dual certifications in HR management, and my goal in taking this course is to improve the HR department's offerings to both the organization and its employees.
Okay, thank you, Ms. Service, and welcome.
Thank you.
Well, my name is Teron Fortune. I'm currently employed at the Royal Bahamas Defense Force. This will be the introduction into my new venture into HR, and just really happy to be here.
Okay, thank you, Mr. Fortune, and welcome.
Good morning, everybody. My name is Marsha Lightbourne. I have been in hotel hospitality HR for more than 12 years. I am currently the head of human resources for Royal Caribbean's private destinations. My reason for taking this course is more personal. I just feel like I need to upgrade myself, and this is the main reason why I'm doing it.
Okay, thank you, Ms. Lightbourne, and welcome.
Thank you.
I don't think we have anyone else. No, no one else. Okay, so now we know a little bit of each other, and we can, I trusted you would have read the introduction to see what the outline of the course is. You would have done that?
I
Yes.
attempted to start, yes, because I
Okay,
collected
so
my
it's
book
good for you
yesterday.
to just read, so you'll see how to prepare for the course. It is generally more or less what is set out here, and most of the information is in the book, but you have reading resources. You have the labor law book. I don't know if that's a part of this first course, because we do employment law 1 and 2. But that is usually helpful. And then, of course, you look at your Employment Act. We have the Industrial Relations Act. And then we would sometimes refer to case law, which is pretty helpful in you understanding the concept and principle behind how they would have arrived at whatever laws or act may be in place to assist the employer or the employee. In this unit, we're going over, we usually start with the introduction, and my method is that we read through the unit and we try to break it down so that you have a better understanding of what is it we're trying to impart to you. So I would ask for class participation. Everybody will just read through, and we'll just go through it more or less paragraph or lines, just so everyone gets a full understanding of what's going on. In this module, your students should be able to gain knowledge of the Bahamian legal system, understand the sources of Bahamian law, gain knowledge of the Bahamian court structure, develop an awareness of key legal principles regarding the legal system, enactment of legislation, and practice of law, and gain an understanding of the conflict resolution in the judicial and quasi-judicial court structure. So once we would have completed this chapter, we should be able to answer those questions above. So Kendra, I see you're still on my screen. I don't know if you want to begin for us with what is law?
What is law? Law is primarily a system of rules and regulations which are enacted through Parliament by way of legislation and development through the decision of cases. Example, binding precedents, local customs or equity, principles or fairness and justice, govern the actions of institutions and members of a country, community, or a community. and are enforced by penalties, example, imprisonment, fines, etc.
Okay, so we have a overview and a summary of what law is. Just another, just let's put a pin here. This chapter is an introduction, and all of the chapters that you're going to go through, once we would have introduced you, the chapters are going to expand on each subject that we would have started with. So it is imperative that you, when we go through each chapter, that you take in, and then we're going to expand. So it's going to seem like it's repetitious, but it's going to be repetitious with expansion, so that once you get the summary, you said, okay, now I realized we would have gone through that in module 1. This is now an expansion of what they were trying to say in that small section, because it's only a summary now, but we're going to expand on it as we go through the chapters. So law is just the system of rules and regulations enacted through Parliament. So we're going to expand on how these things come to being, okay? Go ahead.
Definition of a legal system. The legal rules, legal institutions, and machinery which operate within a particular geographical location or jurisdiction to regulate the many relationships which exist within the society between persons and between persons and the state. That's the definition of a legal system. And an introduction to the law and legal system of the Commonwealth of the Bahamas. The Bahamian legal system is based primarily on English common law, which is a set of legal rules and principles which have developed from judges settling disputes and making decisions in cases in the English legal system.
Okay, so the Bahamian law that we based on is based on English common law, because we have civil law and we have common law jurisdictions. We are a common law jurisdiction. Go ahead.
3 primary types of law. 1, civil law, which includes contract, tort, personal injury. 2, criminal law, which includes murder, armed robbery. 3, public law, which includes administrative law and constitutional law. Sources of Bahamian law. 1, Constitution of the Bahamas. 2, English common law. 3, Bahamian case law. 4, Bahamian legislation or state law, which consists of primary legislation and subsidiary legislation. 5, custom, and 6, equity.
Okay, so this section tells us where we get our laws from. This is the source of where we get laws that are enacted, or how we interpret law. So it's either through the Constitution, it's the English common law system, it's the Bahamian case law. So English common law includes cases that are derived from Commonwealth jurisdictions, but primarily we get them from the highest court, which is the Privy Council. That would be our determining law. And then we have Bahamian legislation, statute law, which is primary, which is the legislation that is first enacted, and subsidiary, which is legislation that would have been amended or added to the primary legislation. Customs, which have been enacted, which we would have gone through, would be adopted more or less as a custom. And equity, which we believe is fair. Equity is a law that more or less looks at what should happen based on what was intended to happen. So it's more based on fairness. Go ahead. Any questions first?
No, so
Okay, go ahead.
Judicature of the Commonwealth of the Bahamas. Judicial Committee of Her Majesty's Privy Council, the Appellate Court. 1, highest court of appeal in the Bahamian court structure. 2, appeals are normally heard in England, although several appeals are being heard in the Bahamas. 3, hears appeals from the Court of Appeal. 4, comprised of law lords.
Okay, this judicature of the Commonwealth of the Bahamas now tells us how our courts, the court system is structured in the Bahamas. So this is the Privy Council. This is the highest court of appeal in the Bahamian court structure. So this is important to note how our court system is set out. So we go over how the court system, what is the highest court, what it does, what it's comprised of. So that when it's now referred to, because it's going to be referred to in some of your questions in exam, you'd now know where I can appeal. So if I ask you a question, Sally took her employers to the industrial tribunal. She wasn't satisfied with the ruling. Where can she appeal from this point? What remedies are available to her? This is where this play comes into play. The court structure. So you should be able to say what the court structure is, where she can go to appeal if they're on the same level, or if she has to go higher. So let's pay attention to this court structure. The Judicial Committee is the highest court, that's the Privy Council. And this is what is included, what they have. They're the highest court of appeal in the Bahamian system. The appeals are heard in England, although sometimes they sit in the Bahamas. That has been here of late, but it's not happened, of course, in the environment we're in for some time. They hear appeals from the Court of Appeal, and they're comprised of law lords. Okay, let's go ahead.
Sorry, Ms. Dorset, what are considered law lords?
So they are judges. We'd call them judges here. So they're the same, like the Court of Appeal is, they have 3 judges sitting sometimes to hear matters. So it's not just one judge hearing your matter, it's more than one. And I don't know, you may be more familiar with seeing the Supreme Court of the United States, where you have all of the judges sitting to hear applications, as compared to you going into a court where there's one justice sitting, as at the Supreme Court. Now, there's provisions in the Court of Appeal that you may have one judge sitting, but in the instance of the Privy Council, it's usually more than one, and they're called law lords, not judges as we are here. So they're referred to as lords at the Privy Council.
Okay.
And I mean, you would hear the phrase when you're in court, if you've ever attended, the attorneys would refer to them as my lord or my lady in the Bahamian system. So that's more or less, but they're called law lords, and we refer to our judges as justices or judges of the Supreme Court.
Okay.
Okay.
Yes, thanks.
Okay, you could continue, please. Any other questions?
Oh, sorry.
You understand that this is the highest court that we've just referred to. So we could put them in the lineup, like number 1, and then go down. So we'll know how the structure is. So it's like a triangle, and they're at the top of the triangle.
Okay. Okay. Court of Appeal, Appellate Court. 1, the highest resident appeal court. 2, the Court of Appeal had jurisdiction in constitutional, criminal, and civil matters, which includes enforces fundamental rights and freedoms, Arts 16 to 27 of the Constitution as acts, that should be acts, I guess. Hears appellate cases for civil and indictable offenses year-round. Hears appeals from the Supreme Court and some appeals from the Magistrates Court. Hears appeals from the Industrial Tribunal under Section 64 of the Industrial Relations Act, Chapter 321. The court also has jurisdiction to hear appeals from interlocutory decisions in civil cases in the Supreme Court, usually with the leave of the trial judge or the Court of Appeal. Comprised of the President of the Court of Appeal and 4 other justices. 3 resident justices of appeal and 1 non-resident justice of appeal normally sit to hear appellate matters. The Chief Justice may also be invited. May also be invited to sit as a member of the Court of Appeal.
Okay, so the Court of Appeal is our resident appeal court, and it's the highest appeal court in the Bahamas that is resident. And we usually have the president of the Court of Appeal, who I don't know, you know who's the president now?
Is that Parker?
No, that's the Bar Association.
Oh,
He's the president of the bar. No one knows. Yes, somebody has.
John Isaacs.
Sean, he's now sitting as acting president, eh?
Miss,
Is it
of the
Longley?
Court of Appeal.
Just the Court of Appeal. I think he's sitting as acting. I don't know if Sir Michael Bonnet is already left, but he was the last president. I know they've sworn John Isaacson as acting president. I don't know if he's been confirmed into position as yet. But I know it was between those two. So it's between John Isaacs and Sir Michael Bonnet. And so, and then we have one who's, well, we have more than one. They're resident judges, but they, of course, are not Bahamian judges. And they've moved, well, one is moved through the Supreme Court system, and one was just appointed there not recently, but a few years. So it's more or less recently. But it's usually, the matters are usually heard there where you're not pleased with the decision that was made in a lower court, and they enforce more or less what should have happened below, or they would say that it has happened. So sometimes it's just on a point of law that you really usually go up there, and they hear your case based on what wasn't done below that should have been done in accordance with law. So it's more or less on what hasn't happened at the lower court, what should have happened in law. So it's not on, I didn't feel it didn't happen here. It has to be something they didn't do in accordance with the law. Okay. Any questions on that? They also can hear interlocutory applications, which is where the case has not been decided yet, but is a point they someone wants to bring up, but they usually have to get leave of the court, or they can get leave of the Court of Appeal if leave is not granted below. Any questions? So the Court of Appeal is our highest resident court of appeal, and that's the second tier in our court structure. So that's where we tip off in the Bahamas, and then when we want to overturn whatever happened here in the Bahamas, we go outside to England at the Privy Council. Okay, go ahead. Okay, Kendra, I'll give you a break now. You feel like you're done. Let's go to someone else to help you out now. I appreciate it. Thanks. Who will go next for us?
I'll continue. Oh, okay. Okay.
Okay.
Thank you.
Am I to continue?
See, Toran was on.
Okay.
I'll go. Supreme Court. First instance, an appellate court. Here are civil matters, which are normally, that part is cut off, which are normally single judge and criminal matters. Example, indictable offenses such as murder, robbery, etc. Bail applications, trials by jury, and matters where the, defendant elects a trial by jury, which are normally heard by a judge and jury. Here's appeals
Okay,
from
so
the
before you move on, Toran, so they hear civil matter where the claim is $5,000 or more. So that's what that example was. So you can hear in the magistrate court claims under that amount, but in the Supreme Court is 5,000 or more. You heard me, sorry.
yes. That's right.
Okay, go ahead.
Here's appeals from the magistrates courts and various tribunals. Here's family matters, admiralty, probate, common law, equity, and commercial matters. Here's criminal and civil appeals from the decisions. Pieces of my thing are cut off, like at the ending. So I don't know what that
Okay.
was supposed to be.
Of stipendiary and circuit magistrates in magistrates courts.
Yes. Here's
You have, okay, good, okay.
Here's constitutional matters. Sits in New Providence and Grand Bahama. Sits through the legal year, which begins the second Wednesday in January. Comprised of the Chief Justice and 12 justices of the Supreme Court. They are appointed by the Governor General acting on the advice of Judicial and Legal Services Commission. 2 resident justices are in Freeport, Grand Bahama.
Okay, so the Supreme Court is our 3rd tier, and they hear civil matters where the claim is 5,000 or more. So if you have a matter that's below 5,000, you need to go to the magistrate's court. So you may be claiming someone has, they owe you $1,000. You won't go to the Supreme Court for that. You would go to the magistrate's court. If they owe you more than 5,000 in rent, unfortunately, you don't have the magistrate court to go to. You have to come up to the Supreme Court, and it costs you a little bit more. So usually when people have small matters, they prefer to go to the magistrate's court. Your dates come earlier, and you have less cost involved in appearing in the magistrate's court. The matters are heard by a single judge. So it's not as in the Court of Appeal where more than one judge sits. It's just by a single judge, and it can be heard by judge and jury. So you can elect whether you want to hear by jury or you want to hear by judge and jury, but it's usually a judge and jury that hears the criminal matters, and in civil matters is usually heard by a judge. They can hear appeals from the magistrate's court. So usually you'd see that in instances where we have persons who would have applied for bail, but the magistrate's court are limited. Their jurisdiction won't allow them to grant bail. So the person can now go to the Supreme Court to ask for bail because it's outside of the jurisdiction, or you may not be satisfied with a ruling of a magistrate and you can appeal at the magistrate's court. So they hear divorce applications, probate applications, and admiralty, commercial matters, and they also hear constitutional matters. So we would have just begun the legal year on Wednesday. So you would have seen that being broadcast locally, where they begin the legal year, and they sit throughout the legal year, which begins every second Wednesday in January. It's comprised of the Chief Justice, who is our current Chief Justice. Anyone?
Brian Maury.
Yes.
Brian Longley. Oh,
No, this one is Sir Brian Maury.
okay.
And we have 12 justices. We may have a bit more now because they've been appointing justices here of late, but of course we have some coming down as well. Acting on the advice of the Judicial and Legal Services Commission. And we have 2 resident justices in Freeport, Grand Bahama. I think we may have additional ones as well in Freeport now. Any questions on the Supreme Court? Okay.
Ms. Dawson, I'll say none now, but I guess perhaps as something comes up, I'll probably.
You can ask, certainly.
Yes, ma'am.
Okay. Thank you too. Okay, let's continue, please. Toran.
Could I kindly pass it on to someone else because
Certainly.
a hard copy?
Okay, no problem. Who was going to help us next?
I can go.
Thank you.
Magistrates Court, First Instance and Appellate Court. These courts are presided over by stipendiary and circuit magistrates and lay magistrates. Hears criminal matters for summary matters and indictable offenses, which are heard summarily, where the penalties are no more than 5 years imprisonment or a $10,000 fine. Hears prima facie cases to determine whether the evidence is sufficient for a prima facie case to be made against a defendant. Here, civil matters where the amount or property claimed to be recovered does not exceed $5,000. Additionally, where the title to property is disputed and the value of the property does not exceed $200. Here's appeals for civil and minor criminal convictions from lay magistrates and the Family Island Administrator's Office. Comprised of such specialized court as the juvenile court, night court, including traffic court and domestic court. There are 15 magistrates courts in New Providence, includes 1 drug court, 1 firearms court, 1 coroner's court, 1 night court, and 2 night traffic courts, 4 in Grand Bahama and 1 in Abaco. There is also a resident magistrate in Exumer and Eleuthera.
Okay, so we have,
Okay.
this our 4th tier, the magistrates court, and they're usually presided over by the stipendiary, the circuit magistrate, or lay magistrate. So they may have lay magistrates in the Family Islands who may be like the administrators, who would hear matters that are not so serious and what they can actually give a ruling over. So it may just be something such as licensing in that island, or something's in not of any moment that they would need more experience in presiding over. So it's more like administrative matters. They hear summary matters for indictable offenses, which are where the penalties are no more than 5 years or $10,000 fine. So sometimes you would have heard on the news where persons would be more or less, they elect to have their matter heard in the Supreme Court or the Magistrate Court. And most often they usually want it at the Magistrate Court, whereas within the jurisdiction of the Magistrate Court, because at the Supreme Court, of course, you open up yourself to more years imprisonment or greater fines. So you'd want to stay at the level of the Magistrate Court, where they are guided or bounded by certain, I guess, acts, laws, rules, where they can't go outside of that. So in this instance, $10,000 fine or 5 years imprisonment. So, you know, if I elect to stay down here, I can't go up to jail for more than 5 years. They hear cases that, prima facie cases, where on the face of it, the first impression is that they have enough evidence to determine whether or not a case can be made against a defendant. So on the face of it, the evidence provided, they can make a determination. So they hear that, and then it's moved on if it's determined that it needs to go further. They hear civil matters where we say it doesn't exceed $5,000, and where the property dispute, where there's property disputed, the value of the property does not exceed 200. So if you have a real property issue, whereas you have a dispute over land, it's not to be taken at the Magistrate Court because it's outside of their jurisdiction. So in some instances, you may be disputing that someone owns property. That's not where you would take your matter. You would have to take that on to the Supreme Court, because they don't hear matters where the property is in excess of $200. They hear appeal for civil and minor criminal conviction from lay magistrates or the Family Island Administrator's Office. And they have specialized courts. Of course, this is a fluid system, so they're constantly changing or upgrading what courts they have in place. And so this is an overview of what usually is in play, but sometimes, of course, they may add courts, or they may take away some based on personnel resources and what the demand is for. Any questions on the Magistrates Court? No.
I can ask one. If
Go
a
ahead.
person elects to have their matters heard in the Magistrates Court, does the magistrate in that court have a right to I guess escalate it to another court, even if it's within their jurisdiction or within their portfolio? Can a
No,
magistrate go
that's-
over a person's elect?
No, not usually. That's the privilege of having the election. That's their choice to elect where they want it to be heard. So that's a right that they have. So we went over that sources of Bahamian law. So constitutionally, they have that right of election.
Okay.
Okay.
I can continue?
Okay, yes, thank you.
Okay. Family Island Administrator's Office, First Instance Court. Matters heard by lay magistrates, example, Family Island Administrators. Here's civil matters where the amount claimed does not exceed $400. Here's criminal matters of a less serious nature, summary offenses, example, petty theft. Appeals from conviction or civil matters may be made to the magistrate's court.
Okay, so you see this is a little small court and it won't take any serious offenses on. And so, of course, you can appeal it at the magistrate's court, where we said earlier. So that's our entire triangle. We have Privy Council at the top, the Court of Appeal second, Supreme Court third, Magistrate's Court fourth, and then we have the Family Island Administrator's Office, which is our fifth tier. Any questions? Okay, so go ahead and read.
Okay, note, first instance courts where matters are heard for the first time or are originally commenced or tried. Appellate courts where convictions from criminal matters or decisions from civil matters are appealed.
Okay, so they refer to the first instance court and that's what is meant by the first instance. So we saw that next to the Supreme Court, Magistrates Court, and the Family Island Administrators Court. That doesn't happen at the Court of Appeal. They're not a court of first instance. So the matter won't be heard for the first time at the Court of Appeal or at the Privy Council. They are courts, appellate courts. They hear matters where conviction from criminal matters or decisions from civil matters are appealed. That's the difference. So if someone asks you, give me an example of an appellate court, you have two, and give me an example of a first instance court. How many do you have?
Two?
We have three, eh?
Yes,
We have
three.
Supreme, Magistrates, and
and
Family
the
Island.
Family Island.
Right. So we have some of our, we know the judicature system now. Yes? Okay, let's continue.
Okay, someone else want to go or you want me to continue?
You can continue, please.
Okay, general legal terminology. Ratio, the reason for deciding the principle of law in a decided case. The ratio becomes the binding precedent in a case. Judicial.
Okay, so this, before you go on, this is the legal precedent. This is the legal terminology, sorry, that is used, and we're gonna find that we're gonna use this throughout the other chapters. So the ratio is the ratio in a case. So it's the reason for deciding and the principle of a law in a decided case. So this is in a legal case that has been decided. This is the reason for the decision of the judges. So when they ask you what is the ratio in that case, they're asking you what's the reason that the judge used for making his decision, whether it was for the defendant or for the appellate, for the plaintiff. Okay, and then it becomes binding precedent in a case. So it's the principle that now we'd use to say why they came to the decision, and we'll use this ratio in other instances when we go to court to say based on the ratio in this case, and we use in that case, this is how the judge came to his decision. So we're telling the court more or less you should follow the ratio in this case. Any questions on that? Okay, let's continue.
Judicial precedent, a decision in a case based on an assessment or adjudication of the facts which may be persuasive or binding. Binding precedent, a decision in an earlier case which a later court is bound to follow. The decisions of a higher court bind lower courts.
So where we find binding decision, the binding precedent, where we get that from?
The highest court,
Okay, but what is that called? What the binding precedent is for?
Ratio.
Right. Okay. So you see how it just connects now? Yes, no?
yes, yes.
Ah, yeah.
Okay,
Yes, I see.
I was
Okay.
making notes.
okay. Go ahead.
Take the notes.
Examples, decisions of the Judicial Committee of the Privy Council. 2, decisions of the Court of Appeal. 3, decisions of the Supreme Court. B, persuasive precedent, a decision which a later court is not bound to follow, but may be influenced. Examples, obiter dicta, is that the correct pronunciation?
They usually say better, but you can, I guess, go ahead. It's better dicta.
Obiter dicta statements. 2, decisions of lower courts. 3, decisions of foreign or Commonwealth courts. 4, decisions of courts of equal authority.
Okay, so in the persuasive precedent, it's statements, obiter dicta statements they made, by the way, in the court, in the decision. So it is only persuasive, but the judges are not necessarily bound to follow it. Or it's a decision that was made in the lower court. So of course, it doesn't have any bearing on a higher court. It may be a decision that was made in a foreign court or a Commonwealth court. And it's a guide. So when you use this persuasive precedent, you say in a court, in a court, they decided that they gave reason behind why this should happen. Now the judge is only guided by it, but it doesn't bound him to follow what they've done. If he see there's reason to it and it makes good sense, he can now use it in his case, but he's not bound to follow it. Again, it may be decisions of a sister or a brother judge. That means they're all on the same level, and he may use it, but it's nothing that he's bound to follow. But we use it as persuasive so that he can say, we'll say, well, you know, your sister judge in the last instance in a case before them decided that based on what is before you, they would have made the decision to go ahead with it, and they can be guided by it, but they're not bound to follow it. So the persuasive precedent is not as the binding precedent, which is a ratio where the decision was made in the case. That's binding precedent. Unlike when the obiter dicta statements are made, it's just statements that the judges made in their judgment, they call it by the way, and it makes good sense, but it's not binding on any court below it or for you to make any decisions moving forward on it. So it's just persuasive precedent. Any questions on that? Okay, let's continue.
Stare decisis, to stand by the decision. The court is bound to follow the binding precedent. Distinguishing.
So unlike the persuasive, the stare because it's now binding precedent. You can't. That's a decision that's made by a higher court. You are bound to follow it. You can't now create your own precedent. You are a lower court, so you're bound to follow it. Go ahead.
Distinguishing. Finding sufficiently cognate facts facts in a later case of similar facts, which may differentiate it from an earlier case and allow the court to make a different decision or ruling from the earlier case, where it would be otherwise be bound to follow the earlier decision.
Okay, so if I use a case where there's binding precedent and the judge is what? Stare, what he has to do? I'm using a case where two cars were riding in different directions and they knocked down a pedestrian. The court determined that the car traveling east, based on what happened, was wrong, and they gave their reason why they were wrong. In this case, two cars were traveling east and westerly. However, the car on the east did what the car on the west did. So what happens? The facts are different, right?
Yes. Yeah, based on travel. Yeah, based on
Right, so
traveling.
they're traveling in the same direction, but what happened was, in the earlier case, the car traveling east did certain things. In this later case, the car traveling east did what the car traveling west did. So in the earlier case, east and west, they did certain things. In this case, now it's more or less east and west doing what west and east did in the earlier case. So what we calling that? They're distinguishing, eh? Because sufficiently cogent facts in the later case of similar facts differentiate from the earlier case. So then is the court minded to include stare decisis in this one?
No,
Are they bound to follow the earlier case?
no.
Yeah.
Because it's
No.
distinguished, right?
Yes.
Yeah, so now it's distinguished. We can show that clearly the facts are different in this case than the earlier case. Whilst it may be similar, there's certain cogent facts that are different from the earlier case. Have I sufficiently explained the difference? Do you understand that?
Yes, it's clear.
Yes.
It's clear, or you need me to use a different example? That's clear then.
It's clear.
Okay,
Yeah.
thank you. Okay,
I
we
think,
can you continue, Ms. Palacios, or you want me to pick on someone else?
I guess someone else can have an opportunity.
Okay, next,
can-
thank you,
I
Ms.
can go
Palacios.
on. That's fine.
Thank you.
All right, 3 major rules of statutory interpretation. There are 3 major rules of statutory interpretation that judges use in interpreting statutes. 1, literal rule. The rule of statutory interpretation that allows judges to interpret a statute according to its literal and grammatical meaning, notwithstanding the outcome of such interpretation. The same word must have the same meaning throughout the statute.
So literally, we usually say someone took something literally. In this instance, the judge is following literally and grammatically what was put in there, because that's what was intended to be interpreted. So this is the literal rule. So in some instances, the interpretation, the statutory interpretation, so what are they interpreting?
Hi, Ms. Dorset.
Go ahead.
You were breaking up?
Okay, am I still breaking up? Sorry.
No, I can hear you now. I mean, I don't know if it was my side, but I wasn't able to hear.
Okay, in this literal rule, this is, what are they interpreting first of all? What we doing here?
Statute according to the grammatical meaning.
So we interpreting statutes here.
Yeah.
And this is the major rule. So we make sure to outline that we have 3 major rules for statutory interpretation. And in this instance, the judges are now using the literal rule. So what they're doing is, if a statute says what? You're not to travel, let's just say we were using curfew. At 10 p.m., you're to be off the streets. They have to take it as literally. It says, it's according to its literal and grammatical meaning. 10 p.m., you're supposed to be off the streets. It's not left for any other interpretation. They are to interpret it literally. So you can't say, well, 10 p.m., but he had to consider that 10 p.m. I would have had to do this, that the architects of this statute were thinking something else. No, literally, in that instance, it would be taken at its literal and grammatical meaning. So the same word must have the same meaning throughout the statute. So in this instance, they say curfew begins at this time, curfew ends at this time. So once it's repeated and however it's interpreted at the beginning, it's to be interpreted throughout the statute as meaning the same thing. So you can't change the meaning of it later on. So they may say, let's use a word that let's say during the day time, we would have already established, I don't think that's a good example. The same word, it must have the same meaning throughout the statute. So you may be able to, you should be able to.
I was gonna ask Ms. Dorset that if the may and shall rule applies with this literal rule, is that a part of this literal rule?
Well, may and shall is definite. You may be able means it gives way, and you should means you have to do something. So that's not subject to interpretation. May is may, and shall means you have to do it.
Okay.
But okay, let's say we say literally the car should not the car should be 10 inches from the curb, or should not park within 20 feet of this home, or you should not build within 20 feet. Literally, that has to be, it's literal and it's grammatical. It means you cannot do it within that boundary. So throughout the statute, wherever it's referred to, you can't interpret it to be anything else. It's interpreted throughout as the same thing. It means the same thing throughout. The boundary is the boundary is the boundary throughout. You can't change the context of it within the statute. And so it's interpreted throughout the whole statute, literally, meaning the same thing, the boundary. Is that any clearer? Is it clear first?
No,
or-
yes, I was trying to get an understanding of it, the interpretation of the literal rule, yes.
So when we say somebody took something literally, so if I said, you are to jump off the bridge, or he jumped off the bridge with what he said, is that it? Do I mean he literally jumped off the bridge?
No, but I guess if a person takes it literally and jump off, then that's where it
Right.
came.
So if I'm saying something like that, I'm not meaning for you to jump off the bridge. He jumped off the bridge literally. But if I say you are to jump off the bridge to get something out of the water, I literally mean you have to jump off the bridge. Yes. So if I literally said you should park within 20 feet of the curb, in the statute, let's use a practical example of let's use that. That's the only way I can give you a proper example. So let's just use the Employment Act. You all have the Employment Act?
No, I don't have that. I have to get it.
Okay, so that's a part of you making sure you have this, because you're gonna refer to that throughout. So it's good to always have it. So let's use something. Let's use something literally. So in every 7-day period, an employer shall allow each employee at least 48 hours of rest with not less than 24 hours of such 24 of such hours being consecutive, and a period of 24 hours rest is in this act referred to as a day off. So can we take it literally that they mean that you should have 24 hours as a day off
Yeah,
within a 7-day period, or that's left for more interpretation?
no, I mean, it sounds like that's literal.
That's literal.
So
That
that's
sounded very
literal.
literal.
In every 7-day period, an employer shall allow each employee at least 48 hours of rest with not less than 24 of such hours being consecutive, and a period of 24 hours rest is in this act referred to as a day off. Can you interpret that to be anything else?
Oh,
No.
ma'am.
So
Tell
that's
us.
literally, you must interpret that to be literal. So when I go to court and I said, I have not had 24 hours of rest off from this job in any given period, and I've worked here for 365 days. I've only been allowed 12 hours at any given period. Is the employee, is the employer at fault? Have they
Yes.
acted in contravention of the law? Yes, so the
Yeah.
judge,
Employer.
right, so the judge can literally apply what is Section 9 of the Employment Act 8-9 says. They should have had 24 hours. So that's how we would interpret it to be. You can't put anything else. It is literal and grammatical. The literal and grammatical meaning is what is supplied. Is that clearer now?
Yes.
Yeah.
Thank you.
Excellent.
Yes.
Okay. Let's continue.
Sorry, I was looking at the employment law. Okay, so golden rule. The rule of statutory interpretation that allows judges to interpret a statute according to the plain and ordinary meaning, particularly where there are two or more literal interpretations of the statute, or where following the literal rule of statutory interpretation would result in a foolish outcome or one contrary to the intention or wishes of Parliament. It is the opposite of the literal rule.
Okay, so in this instance, the golden rule is the rule of statutory interpretation. So you interpret the statute in accordance with the plain and ordinary meaning, particularly where there are two or more literal interpretations of the statute. Following the literal rule would make it foolish to do so, eh? And it would be contrary to the wishes of Parliament. So let's use an example again to help you with in using this golden rule. So let's go back through this Employment Act to give you an example of where they can't use it to literally, more or less, to use the literal meaning. So let's go to this section, one second. Okay, hold it up. Okay, I'm looking for an example. I'll get one. I don't want us to hold up for that. I was looking for it in particular in the Employment Act, so give me a moment with that one. But where there are two or more literal interpretations of a statute, let's just give an example of let's just use the same example we use, and then we'll find a better example because we have one, but I just would have to pull it out of this, and I would have gone through the whole thing. I had one, but I, for some reason, don't have it handy. So in the instance of, in every 7-day period, an employer shall allow each employee at least 48 hours of rest, with not less than 24 hours of such hours being consecutive, and a period of 24 hours rest is in this act referred to as a day off. Just let's say we said, and we put something in there that would more or less give us another literal meaning of it. Let's say, or a day off could be referred to as, if in certain instances is 36 hours rest, they would have gotten, they have, once the period would have been 24 hours, no, it still would, we needed to be two literal meanings. So let's just say we have two more literal interpretations for day off. And in the instance of us having two literal interpretations for day off, it would be foolish. It would make it foolish. The outcome would be contrary to what was intended. So more or less, it gives me where 24 or 36 or maybe 48. So then it doesn't give definitively a period for the day off to be any particular time. It may be 34, 20, it may be 36, 24, or 48. So then what happens in that instance? The judge is now allowed to apply the golden rule and to interpret what, according to its plain and ordinary meaning, that they were intending for it to be a day off. So we'd say they only refer to 36 or 48, but really the architects really intended for 24 hours to be the day off. They use those instances that some people may get 36 hours, they may get 48, but they didn't literally mean that the employee should have 48 hours off as a day off in a 7-day period. They said they just used an example of them having 48 hours or 36 hours as rest period. It doesn't matter as long as they had the 24 hours. So the plain and ordinary meaning was that they should have in a 7-day period 24 hours, notwithstanding they may have added those additional literal words. It doesn't mean that you can have 48 hours off as a day of rest. They only intended for you to have 24 hours. So they make sure that the wishes of Parliament, what they intended to happen when they created the statute, their intention is now followed through with this golden rule, which is an interpretation by the judge of what was the plain and ordinary meaning of what was Parliament's intention in creating the statute. Now, I'm going to give you a proper example of how they would apply the golden rule, but I'm just using it so you can see what is more or less they were trying to interpret there. Okay, I don't know if that's clear enough what I'm trying to impart, but I'll just bring something back up for you in a minute. Okay, is that clear or not really?
It was, for me, it was a little bit of both. It was a bit clear, and then I had a few questions.
So I'm
but I guess
going
as
to give you a
on-
better example. Right, I'll give you a better example, but I just wanted to give you a snippet of what more or less they're saying, where you have two literal interpretations. They're going to use the plain and ordinary meaning to ensure that they don't have a meaning that comes out contrary to the intention of what Parliament actually wanted, or it to look foolish when you would have interpreted more or less the literal meaning, whereas two or more.
Okay.
Go ahead.
Okay, the mischief rule. The rule of statutory interpretation that allows judges to examine a statute to discover and enunciate its purpose and address the mischief that it was designed to prevent in common law. Judges normally interpret the statute in a way that assists in remedying the mischief identified in the act.
So the mischief rule is where there's some mischief created by a statute where they discover that there's a mischief that's created. They now interpret the statute in a way to remedy the mischief. So in the instance where you would have, say for instance, in the VAT Act, we have, where there's a merchant who is now charging VAT on items, he is entitled to recover all the VAT that he pays throughout the year against whatever VAT he collects. So there was a mischief that was created as a result of that. What happened was persons who would have been now VAT registrants who are collecting VAT on behalf of the government was able to now recover VAT. And it could be recovery based on their operational expenses or in, I guess, them purchasing goods, they are able to put in for a VAT credit for that, in them paying light bill, anything that was related to the business. So what happened was they now purchased property belonging to a business. And when you purchase property, what tax is applied? Do we call
Real
it
property?
stamp tax or we call it,
Real
no,
property
we
tax?
purchase it, no, we purchase it.
Oh,
So now we call it VAT tax, eh?
yeah, purchase.
So it's now VAT tax. So when you purchase, if you purchase a property that's under 10,000, under 100,000, you pay 2.5% of the value of the property, which is now VAT tax. And it's usually divided between the purchaser and the vendor. In the instance of a VAT registrant, they may have been purchasing property belonging to the business. So now they may want to recover the VAT that they're going to pay to the government. So imagine if they're paying over $100,000 for the property, they're going to pay 10% on that property, and it's shared between them and the vendor. So 5% they have to pay. So they'd have to pay the government $5,000. So because of how the act was structured, they can now ask the government back. They can put that as a VAT credit, eh? Because that's towards the business, eh? So I can ask for the $5,000. I can put it as a credit, yes? A VAT credit, I'm a VAT registrant and I'm purchasing property that's related to the business operating. Can I put that as a VAT credit?
Yeah, I'm not
Anybody?
certain. That's not certain.
You should be able
Okay.
to.
Oh, no.
Right. So there was nothing stopping them from doing that, because you told me anything that's dealing with the business, I can recover the VAT that I pay out of this business. So the government realized the mischief in that, and they put in place, they would have put in place, they only would have put it in place when it became an issue, because beforehand, I wouldn't know that would have become an issue. Only when it becomes an issue, then we can correct that. So what would have happened before the government would have realized that? Someone brought it up to the VAT department to say, I'm looking for a credit of $5,000 because I purchased this property, y'all charge me $5,000 and I put that in as a credit. So now the real property department would now say, no, that's not the case. You can't get this money back. Literally, the person said, literally, you all have it right here. I'm a VAT registrant, and anything that I purchase towards the business, I can recover. So based on this literal meaning, I should be able to get this back. So now we have to go where to get this sorted out. Because the law is there, the law already says plainly I can get it back. Where we going with this?
The Supreme,
Right, we go to the court. So now the judge has to do what?
Adjudicate on the matter.
Right, so they're examining to discover and see the purpose of what Parliament intended for this, what was intended by Parliament. What did they intend for this to happen? They weren't intending for you to be able to do what? Take money back from the government, eh? It was for you to collect on behalf of the government, and the government in turn would give you some credits back on your utilities, on your operational expenses, but it won't come where you'd be taking money out of the treasury. They didn't intend that to happen, eh? You
no,
think that was their intention?
no, definitely not.
Right, so now the judges see the mischief that was created, eh? So they would address it. And what they would do? They remedy it
And make a ruling, yeah.
and they make a ruling, and then what they do? They send it back to Parliament and say, you need to cure this mischief, eh? And so then we would have a what? We'd have what? What would we start off with?
Amendment to
Right,
the
and we call
legislation.
that what? From our earlier read, we have primary legislation and we
Subsidiary.
have, what's the
Subsidiary
next?
legislation.
Right, so now we'd have subsidiary legislation on the VAT Act. That would make sure to clearly spell out now, you are not entitled to recover what? As a VAT registrant, you cannot recover what?
Real property tax,
You, or what we call in this instance, VAT tax on real property, eh?
Yeah.
In the instance where you're purchasing property, you're not entitled to recover, but the judges would first interpret it to, they have to do their interpretation, which is where the mischief was created. There's a mischief created by this act. And so there's a mischief rule. So the judge now discovers it, addresses it, and now says, no, Parliament never intended for you to recover the government's funds. That's for the government's treasury. They wanted you to assist them in collecting some additional funds, not to take away what they're supposed to collect. So they would now interpret it as remedy the mischief and now ask Parliament to cure the mischief so that it don't come back to their court again, eh? It won't come back once you would have cured this mischief by addressing it. But they would have now cured the mischief in the ruling, because they would now enunciate with the purpose of and address what Parliament intended to happen in this particular statute. Is that clear? Is that clear?
There's a better understanding now.
Much better
Okay.
understanding.
Okay, good. Okay, let's go ahead on the bill.
Okay. How a bill becomes an act of Parliament. 1. Drafting and introduction of the bill. The proposed new statute is drafted in the form of a bill by the Attorney General's office upon consultation with the government of the Bahamas. A white paper or green paper may have been prepared before the drafting of the bill. Green Papers is a government publication that details specific issues and then directs possible courses of action in terms of policy and legislation. It is usually commissioned from the relevant departments if the government feels that there is an area where new legislation is required or existing legislation needs to be revamped. A green paper contains no commitment to action. It is more a tool of stimulating discussion, but it is often the first step towards changing the law. Green Paper on Independence. After publication, Suggestions contained in the paper will be up for public consultation and debate. These discussions will lead into the white paper. White papers are issued by the government as statements of policy which set out proposals for legislative changes or the introduction of the new laws like value-added tax on a particular topic for which the drafted bill may have been researched and prepared before the drafting of the bill. The bill is introduced in the House of Assembly.
Okay, so we have the drafted and introduction of the bill. So we have white or green paper being prepared, and it's usually addressed from within certain ministries. So they would say, we need to ensure that we're trying to work on renewable energy. We need to now look at what acts are available for renewable energy. And if there are none available, we need to come together with BPL and ERCA and look at what statutes are available and now try to incorporate some legislation that deals directly with renewable energy. So the departments who are now working behind the scenes in renewable energy would be working on draft or proposals to the government to say, we need to implement this in order for renewable energy to work. We need to do this. BPL only deals with electricity. They don't deal with regeneration of electricity. They don't deal with how it will be regulated. They don't deal with how billing would come about, how it would benefit the country as a whole. So now we need to look at BPL and work with them in trying to put in to play renewable energy. Then we'll go to ERCA to see how they guide the utilities industry and to say, well, based on ERCA's rules, we need to put this in here to assist in renewable energy. So all of this is happening. So they would create papers that would be proposals to the government to say, if we are to put renewable energy in place, we need to put these things and we need this to happen, we need that to happen. So now they would propose and draft legislation. And it's initially for discussion in a town setting. So, and you get ideas from your public when you go into a town setting. So you would have already created a white paper saying what you're proposing, and then you get feedback from the general public to say, they give you ideas because they may say, oh, but if you do this, this will affect me this way. So now the draftsman should be there to take all of those comments and concerns in, and now they would tweak what they would have proposed based on the ideas they receive from the general public or from the community and the stakeholders. And now they're able to set out a white paper for legislative changes to enact renewable energy within the utility environment. And so we have that instance on the green paper where they want to change law. And that came about in independence. So they changed law to move from a colonial system into your own independent system. And then they did the VAT Act, where they did a white paper to incorporate value-added tax as a system in collecting taxes for the government of the Bahamas. And it's a bill that was introduced into the House Assembly for debate. And so usually if any changes are to be made, it'll be done at the House level where they would have debated the bill, and based on what feedback they get in the House, after they would have gotten all of this feedback, now they can say, well, we've agreed. The majority would agree that, yeah, this should proceed with this, or this should proceed, but let's make certain changes based on the feedback we get here. Okay? Yes? Any questions?
No,
Everybody's still here, right?
I think it's understood.
Okay. Okay, let's proceed.
Okay. Number 2, the first reading. Bill is tabled in the House of Assembly and it gets its first formal reading. Members are advised that the bill is available for reading. You want me to continue? Just keep going?
Yes, keep going.
Okay.
So let's pay
Sec-
attention to the steps now.
Okay. Number 3, second reading. The bill receives its second formal reading and the provisions of the bill are debated. However, no amendments are proposed at this stage. Although the second reading and committee stage may be combined and amendments made. 4, committee stage. Select committees may be formed as necessary and amendments may be proposed at this stage. 5, report stage. The bill is returned to Parliament where the amendments are debated. 6, third reading. The bill receives a third reading and is voted upon by members of the House of Assembly. The bill is passed in the House of Assembly. 7, Senate. Bill is sent to the Senate for tabling, debate, and discussion. Amendments may be made by the Senate and the bill returned to the House of Assembly for consideration. Otherwise, the bill is approved by the Senate. 8, royal assent. Once the bill is approved by the Senate, the bill is placed before the Governor General to receive the royal assent. Once the royal assent is received, the bill becomes an act of Parliament.
Okay, so we have the stages from how it becomes an act of Parliament. It's introduced as a bill. There's a first, a second reading, then it goes into committee stage. It's at the report stage, the third reading, then it goes up to the Senate for tabling and debate, and then it's assented to by the Governor General. What we're going to do is to assist you in understanding this. During our 5 weeks together, we're going to see if the House of Assembly has any of these things happening. So I'd ask you just to follow to see if they have any bills that are being introduced. I will see if they have anything and we'll try to follow, and that will be like a little ongoing thing we'll do up to the 5 weeks, okay? We're gonna see what happens by the end of the 5 weeks, whether we had any bills that have been introduced, are they at any first, second readings, committee stage, report stage, third readings. You're gonna be able to tell me, and if anything is debated up in the Senate. So let's make that a little assignment for us to do within this 5 weeks. Yeah.
Sure.
Okay. So
Sounds good.
you can just follow whatever stage you meet it at. You just will give me an overview of it. Okay. Is that fine?
Yes, ma'am.
Thank
Yes,
you.
it is.
Okay. Okay, so let's wind it up now.
Okay, primary legislation. The primary laws which govern employment law in the Bahamas are statute laws and common law. Statutes are the Employment Act 2001, the Employment Amendment Act of 2017, the Minimum Wages Act 2002, the Minimum Wages Increase in Minimum Wages Order 2015, the Health and Safety at Work Act 2002, the Industrial Relations Act 1971, the Industrial Relations Trade Union Regulations 1971, the Industrial Relations Amendment Act 2012, the Industrial Relations Amendment Act 2017, and the National Insurance Act 1972 Amendments and Regulations.
So in this area, we should be able to now do what? If we are studying and we are following employment law, human resources, we should know that all these statutes we should be aware of in this area, eh?
Yep.
So these govern employment law. So you should have these in your back pocket somewhere so you'll be able to refer to them. So you can have all of these just as a tab or your favorites on your bookmark in your on your computer so that you can pull up any at any given time to be able to refer to anything that may come before you. Because we have some recent changes in the Employment Act as well, eh? That the emergency orders affected, right? Yes?
Yes.
Yes. Okay. Okay, so let's go over our notes. So we'll see what our notes tell us.
Judiciary applies and interprets law. The Privy Council is Her Majesty's Judicial Committee. It's the highest court to which appeals may be made from decisions of the Court of Appeal. Then we have the Court of Appeal, which is Justices of Appeal. It hears civil and indictable criminal matters, some appeals from the Magistrate Court and various tribunals. Then we have the Supreme Court with the judges. They hear appeals from magistrate courts and various tribunals. Then we have the magistrate courts, which is the S&C magistrates, hear civil and criminal matters. Then we have the Family Island administrators. They hear minor matters.
Excellent. Now, the S&C are who? S&C magistrates are who? What does S&C stand for? Not everybody answered once, just one at a time.
Stipendiary and circuit magistrates.
Excellent, excellent. Okay, let's go to our Court of Appeals structure. God, we have the Hartman sitting up here. What is this? Why do they have that up there? Okay, I think y'all were following this this administrative structure, but of course it's changed since then, eh? It's still showing Sir Hartman as the top?
Yes,
Yes,
it
it
is.
is.
Okay, interesting. Okay, so let's make sure we fill these out correctly. We'll follow this and we'll make sure that for the next class.
You want me to just read them as is, though?
Them as this, and then that will be our homework, okay?
Sorry, you break up just now. for
Well,
me.
this is just the homework for next week.
Okay,
Our homework for the next 5 weeks is to do what? For next week.
Look for a bill that's possibly in the process.
And follow the process for it.
And fill in these blanks to make sure that these names are correct, okay? Yes? Hello?
Yes. We
yes.
can hear you,
Okay.
Mr.
Yes.
Okay, good stuff. Okay, go ahead.
That is all I have, and then we go on to the self-assessment questions.
Okay, you read all of the names already?
So
No,
the
eh?
name, no, so the names we have as president, Sir Hartman Longley. Then for the justices of appeal, we have the Honorable Mr. Justice John Isaacs, the Honorable Madam Justice S. Maureen Crane Scott, the Honorable Mr. Justice Roy Jones. For registrar, we have Sharada D. Ferguson. Deputy registrar, we have Ingrid Cooper Brooks. Then we break into three. For the clerk of the list, the court administrator, the office administrator, and then we break into 3, 6, 8, which includes personnel, material management and library acquisitions, accounts, registry, court reporting unit, court security, computer unit, and library.
Okay, so for sure we know we have even more justices of appeal. So we only need to fill out from the president right to the deputy registrar, okay? Let's just make sure that we have the right names in our little boxes, okay?
Okay.
Okay,
Okay.
so let's answer our questions. Now, our questions are answered by you telling me What page I will find the answer on, and then you give me the answer. So number one, define law and a legal system. Where will I find that answer?
Page 11.
Page
Page
11.
Okay. And what is law and a legal system? What is the definition?
Law is primarily a system of rules and regulations which are enacted through Parliament by way of legislation and developed through the decisions of cases, example, binding precedents, local custom, or equity. Govern the actions of institutions and members of a country or community and are enforced by penalties,
Okay.
and fines.
And what is the legal system?
Legal system, the legal rules, legal institutions, and machinery which operate within a particular geographical location and jurisdiction to regulate the many relationships which exist within that society between persons and the state.
Excellent. Okay. Outline the Bahamian court structure. Where would I find that?
Page 12.
Page 12. And what is the Bahamian court structure?
The Judicial Committee, which is the Privy Council,
Mhm.
the Court of Appeal, the Supreme Court, the Magistrates Court, and the Family Island Administrator's Office.
Excellent. So that's between 12 and 13.
12 and 14, yes, ma'am.
12 and 14, yes. What is the highest court in the Bahamian court structure? Where do I find that answer?
Page 12. The
Page 12.
Judicial or the Privy Council.
Excellent. What are the three primary types of law? Where would I find that answer?
Page 11, civil law, criminal law, and public law.
Page. Everyone got it? Okay. What are the sources of Bahamian law? Where would I find that answer?
On page 12,
Page 12. What are the sources?
Constitution of the Bahamas, English common law, Bahamian case law, Bahamian legislation, statute law, custom, and equity.
Excellent. Number 6, define the ratio decidendi and stare decisis. Where would I find that answer?
Page 15.
Yes.
Okay, what is the ratio decidendi?
The ratio decidendi. The
This
reason,
ratio. Mhm.
the reason for deciding the principle of law in a decided case. The ratio becomes the binding precedent in a case.
Okay. And stare decisis.
Stare decisis, to stand by the decision the court is bound to follow, binding the precedent.
Okay. Define distinguishing for me.
Page 15.
Where would I
as well.
find that answer?
Page 15 as well.
15.
Finding sufficiently cogent facts in a later case of similar facts, which may differentiate it from an earlier case and allow the court to make a different decision or ruling from the earlier case, where it would otherwise be bound to follow the earlier decision.
Excellent. Okay, what are the two types of precedent and define, please? Where we'd find that answer?
Page
Page
15 as
On
well.
page 15,
Okay, what are the two types?
Judicial and persuasive.
What is it?
Binding and persuasive.
Right,
Yeah.
binding and persuasive. And what is binding?
Binding, a decision in an earlier case which a later court is bound to follow. The decisions of a higher court bind lower courts.
Okay, and persuasive?
A decision which a later court is not bound to follow but may be influenced.
Excellent. What are the three major rules of statutory interpretation? Where we'll find that answer?
page 16.
Page 16. What are the three major rules?
Literal rule, golden rule, and mischief rule.
Mischief rule.
Excellent. Now, explain how a bill becomes an act, where we'd find that answer.
16 and 17.
17.
Okay, 16 to 17, how does it become an act?
Through an 8-part process of
And it begins with,
drafting and the introduction of the bill.
yes, second,
First reading.
first reading, third,
Second reading,
fourth,
committee stage,
fifth,
report stage,
sixth,
and third reading,
Reading.
and then
seventh,
Senate,
and eighth.
royal
Royal
assent.
assent.
And our royal assent is who? Done by what?
Governor General.
Excellent. Okay, so we have gone through our self-assessment questions. Now, we have gained knowledge of the Bahamian legal system, and we understand the sources of Bahamian law. What is the Bahamian legal system all about? Our Bahamian legal system is based primarily on
British common law.
English common law, yes. And it's what?
A set of legal rules and principles which have developed from judges settling disputes and making decisions in cases in the English legal system.
Right, and we know our sources of Bahamian law, which begins with?
The Constitution of the Bahamas.
Right. And that includes our English common law, Bahamian case law, legislation, which is primary, subsidiary, custom, and equity. What about the Bahamian court structure? We know about the Bahamian court structure. What's our highest court?
Privy Council,
And then we go to,
Court of
Court
Appeal,
of Appeal,
then we go to,
Supreme
Court,
then we have,
Magistrate,
Magistrates Court.
and our final,
Family Island Administrator's Office.
okay. What about the key legal principles regarding the legal system, enactment of legislation, and practice of law? What are the key legal principles?
Mm,
We have the binding precedent, which is called the,
ratio,
right? And we have precedents, which are judicial precedents that are binding and
Persuasive.
then we have stare decisis, which is where
we stick to the
the
decision.
court is
You
found.
found.
the court.
And then we have distinguishing, what happens in a distinguishing situation. We have cases that are,
There's
Information that comes later, that,
so they
it's
have,
a different decision at the end.
right, so they're similar, but there are certain facts that differentiate in that instance, right?
Yeah.
And so what usually happens when and what the enactment of legislation does, we go from doing what?
Drafting a bill,
to assent, right?
yes,
Mhm.
drafted to royal assent.
And the practice of us, of the law, how do we, what we use in practicing for what we do? The judiciary does what? Who's the judiciary first?
The Chief Justice, judges.
So the judiciary is the what? The court system?
Mm,
Yes?
Oh, with the Privy Council?
No.
No, the judiciary. What is who's the judiciary?
Or judges?
The court system, eh? That's where they apply and interpret law, eh? So we going through that. So it could be magistrates, it could be judges, it could be law lords, eh? That's the
Mhm.
judiciary. They take care of that arm of government, and so they now apply and interpret law. And then we go through the court system, where different judges would sit and hear and interpret matters for us. Yes?
Okay.
And then we have understanding of conflict resolution in the judicial and quasi-judicial court structure. How do we deal with conflicts? Where there's conflict, we go where?
Court of Appeal.
No, I mean, we start off with first instance courts, yes?
Mhm.
How many first instance courts we
Oh.
have?
3,
Yes, and we have some appellate courts. How many do we have?
2.
Okay, you all already know the system well. All right, so any questions on the Bahamian legal system? So this chapter is clear as day or as mud.
Muddy water.
Definitely muddy water.
So we all just have to do a little run through again, just to make sure.
Yes.
Yeah.
But if you have
Yes.
any questions, was anything not so clear or it was okay?
So far, so good. Everything was pretty good. I mean, I would have asked questions if it came up.
Okay,
Just understanding the mischief rule just a little bit more, but as I work it out in my head, I'll get it.
okay, and I'll give you some examples in any event. I'll send you an email as well.
Thank you so much.
Follow. So now just make sure we do a little bit of our little homework that will help you to stay in the book a little bit, because I know by next week you just may pick up the book again. So let's just see if we can answer those boxes in the meantime and see if anything is happening in the House of Assembly. And let's try to follow to see where they're at with any bill that they've not yet enacted. So we know when it reach up to the Senate, it almost finished, eh? So we're trying to catch something down where?
In the house.
At the
Or we
house.
trying to catch something on the,
Or if
At
we
the-
even catch it out in the
Our third
public,
reading.
we may even catch it in the public. We may find something that is still in the public domain, eh?
what is considered the public domain?
Where they are just having discussions with the public. Remember when we say they have introduced some sort of white paper, or they may just be asking
Green
for you to
paper,
come
yes.
to a town meeting or something. So you know they're trying to determine something when they open it to the general public.
Oh,
They
okay,
want
yes,
your
I see it.
opinion on things.
After publication suggestions contain, okay.
Right, so you can, and then you can even ask publications if they have anything out as well. That is just a bill, or you can call the House of Assembly to ask them if they have any bills on the table. Okay,
Okay.
Okay.
it's just for you to keep engaged a bit.
Okay.
All
Ms.
right,
Dorset,
yes?
you mentioned sending emails to us. Do you have email
Well, I would
addresses?
figure all of you have the same email. We got the Zoom invite on.
Yes.
Yeah, I was going to use those email addresses. Is that fine?
Alright.
Yeah, sure, that's my office. email, that's
Everyone
fine,
got
yes.
the email for this Zoom meeting this morning from that, eh?
Yes.
Mhm.
Okay, so that's what I was going to use. Is that fine?
Yes.
Well, yeah,
Yeah.
because what I had done was I had used my office email, but I would prefer if it goes to my personal email because,
Okay, can you give it to me then?
yes, ma'am. Would you prefer me to spell it out or should I send it in the chat?
You could send it in the chat now. That's why I'll write it out.
Okay, thank you.
Okay, and I noticed that Ms. Isaacs gave you some links in the chat. I think you should try to pull it so you don't have to look for it. Thank you,
Oh,
Ms.
that's-
Isaacs.
I saved those already.
Okay, good.
Miss
Really
Dorset,
saved.
just a quick question. Would
Mhm.
the recordings be sent us as well? Because my internet was in and out.
I think you can actually access those all the time. So what you need to do is find out from the office. They
Okay.
have these that you pull down because sometimes people are not able to attend classes. and they can just go on the site and pull it down and listen to it.
Okay, thank you.
So just check with the BIF's office and see where I think it's YouTube, but I'm not sure. But they usually put them up for persons who would not be able to attend the classes. Okay, I got the
Okay.
email address, Kendra.
Thank you.
Thank you so much. And if
Miss-
you have no further questions, let me know.
I just have one other question concerning the schedule. I know
Okay.
originally when I got the information about the course,
Mm-hmm.
the period ran from the 15th until the 19th of March.
Uh-huh.
And the schedule changed a little bit when I picked up the book yesterday.
Okay.
It's extended until the 2nd of April. And I'm just wondering if which one we're going to be following.
Okay, now the thing is, I won't be able to speak to it because I have an old book. But what you can do is send a note to them for them to confirm it.
Okay.
Just to confirm it for you to make sure of the time, and I will just confirm as well and send it out to you just in case you don't get around to it.
Okay, because the modules are it's still the same amount of modules, but I noticed that it's a little longer. And then,
Okay,
so I just want to confirm the time because I think they said 9:30.
Then,
Then
yeah, I
it was
I was starting at 9:30, but then I saw when I looked in the email, it said 9, but it was too late because I was just opening it up then. So I thought it was 9:30 it began. What was your understanding? Most of you had it for 9 or 9:30?
9,
I thought it was
9:30.
9:30, but until I got all the
9:30.
Zoom requests, it said
9:30.
Okay, yeah, so we're gonna stick with 9:30 because 9 may be pushing it on a Saturday morning.
okay.
Yeah, because Ms. Dean had said that it should have been 9:30 and not 9 as Miguel has sent in the email.
Right, I thought so, because I said, gosh, Lord, I hope they weren't sitting here since 9, but I couldn't get in anyway. I apologize, I didn't even remember to say that.
I think
Okay.
one of the other things that I noticed as well is that the extra 2 weeks might be for the midterm and the end of course exams.
Okay, so you may have some review classes in there. Because they usually do a review class, so that may take up an extra week in both instances because you have part 1 and then part 2. And so they may be giving you a review class somewhere in there for both parts.
15, 20, 29.
But once you follow, like I say, this exam is usually easy if you follow each module and just pay special attention to whatever is pointed out.
Okay.
Okay. And then they have some study resource guides on page 22 in my book. I don't know what page it is in your book.
Yes, it's the same. It's 22.
Okay, good. Okay.
Yeah.
So you all have any other questions?
No,
Okay, so it
so
was,
far, so good.
okay. So let me know if you have any additional questions or concern, and I'll certainly try to address it for you.
Okay.
Thank you so much for attending.
Thank
Enjoy
you.
the rest of your
Thank
short
you.
weekend.
Thank you. Have a good weekend,
Thank you,
everyone.
Ms.
Be
Dawson.
safe.
Be
Okay.
safe.
Yeah.
Take care now. Thank you.
Okay.
Bye.
Have a good day.